In January of 1964, the U.S. Supreme Court saw the case of New York Times versus Sullivan. This case was an appeal from a lower court case in which the New York Times published an advertisement criticizing an Alabama police department for the way they handled a civil rights protest. In the ad, the New York Times wrote that truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus when the entire student body protested to state authorities by refusing to re-register. Their dining hall was padlocked in an attempt to starve them into submission. The ad went on to reference Dr. Martin Luther King Jr., saying, "The Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home, almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and similar offenses, and now they have charged him with perjury, a felony under which they could imprison him for 10 years. L.B. Sullivan was a police commissioner at the time, and he filed a libel complaint against the New York Times, claiming that their words and false statements had damaged his reputation. Even though Sullivan was not named in the ad, he claimed that the references to the police department were directed at him, since he was serving as the police commissioner. Therefore, Sullivan equated that he was the one being accused of ringing the college campus with police and locking the students out of the dining hall. He also claimed that by using the term "they" when referring to the people who bombed Dr. King's home, and also using the term "they" again when referring to the police who arrested Dr. King, the New York Times was directly implying that he was responsible for the bombing and the assault. Initially, the court ruled in favor of Sullivan, and the Supreme Court of Alabama upheld the judgment. However, the U.S. Supreme Court reversed the decision of the lower courts and instead judged in favor of the New York Times. They explained that in public debate regarding public officials, some inaccurate statements are inevitable. Since Sullivan was an elected public official, he did have to provide more proof of defamation than private citizens do. He had to prove that the New York Times acted with actual malice toward him. In this case, actual malice requires that a publication knows the information they are publishing is false, or that they are acting with reckless disregard of the truth. Sullivan failed to prove that the New York Times advertisement was published with actual malice, and therefore the paper was ultimately protected from his claim of defamation. In November of 1973, the U.S. Supreme Court saw the case of Gertz versus Welch. In the lower court case, an attorney named Elmer Gertz filed a complaint against Robert Welch for publishing defamatory statements against him in his magazine American Opinion. Gertz had previously represented a family whose son was murdered by a police officer. Since the early 1960s, American Opinion magazine had been outspoken about a supposed nationwide conspiracy to discredit police and make way for a communist dictatorship. Since Gertz represented the plaintiffs in a case involving a police officer, he became the target of an article in American Opinion that contained what Supreme Court Justice Powell called serious inaccuracies. In the article, Welch claimed that Gertz was an officer in a communist organization that probably did more than any other outfit to plan the communist attack on the Chicago police during the 1968 Democratic Convention. It also called Gertz a Leninist and a communist fronter, despite all of those claims being untrue. Welch did not fact-check the article to determine whether the statements were true or not. He said he trusted the author's reputation as he had already contributed multiple articles to American Opinion. The lower courts initially judged in favor of Welch, as Gertz failed to prove actual malice in the case. However, the U.S. Supreme Court ultimately reversed and remanded the decision, instead deciding in favor of Gertz. They explained that since Gertz was considered a private individual and not a public figure or official, he did not need to prove actual malice in his defamation claim. The allegations brought up in the American Opinion article could have seriously damaged Gertz's reputation, both personally and professionally. He worked as a lawyer, so being publicly accused of associating with communist organizations and conspiring against the United States could have prevented career growth, gotten him fired, or deterred future clients from hiring him. Personally, the defamatory statements made in American Opinion may have caused a tremendous amount of emotional distress and mental anguish. The accusations may have planted seeds of distrust among his family and friends. He may have lost sleep and may have declined in health as a result of the stress. To avoid a defamation suit, Welch could have verified the statements made in his article and chosen to remove any untrue information before publishing. He also could have voiced his opinions and concerns without directly naming Gertz. An important lesson to learn from the Sullivan and Gertz cases is the distinction between private individuals and public figures when it comes to proving actual malice in cases of defamation. As a professional in the communications industry, I will advise future clients against publishing any untrue, damaging statements about private individuals, as they do not have the need to prove actual malice. I will also assist them in finding diplomatic and tactful ways to publicly voice their thoughts and opinions without making defamatory statements about any entity, public or private. While public figures and officials do have to prove actual malice in defamation suits, I believe my clients' reputations are of the utmost importance to protect, and I would advise against releasing any untrue content.